Hello, my name is Andy Zachrich, and I'm a third-year law student at Berkeley Law. This video was created in partnership with Berkeley Law's Name and Gender Change Workshop, the East Bay Community Law Center, and Legal Aid at Work. This video is intended to provide information about how to preserve someone's legal claims if they feel that they have been discriminated against or harassed at work for being trans. This video is only informational and is not legal advice. Specifically, this video will cover these three things. 1. This video will provide background information on anti-discrimination and anti-harassment law for transgender employees. 2. This video will explain what to do if discriminated, harassed, or retaliated against at work. And 3. This video will explain how to file claims of discrimination, harassment, and/or retaliation with the appropriate government agencies. This video is intended for workers in California, but the information about federal law and federal agency filings are applicable across the United States. I'm going to start with providing some background so you have some knowledge of the laws that protect you at work. I will start with federal law and then transition to California law. Title VII of the Civil Rights Act is a federal law that prohibits workplace discrimination and harassment on the basis of race, color, religion, sex, and national origin. Title VII also prohibits retaliation. In a 2020 Supreme Court case called Bostock v. Clayton County, the court held that workplace discrimination because of gender identity or sexual orientation violates Title VII's prohibition on discrimination on the basis of sex. Title VII covers employers with 15 or more employees. The law forbids gender identity discrimination when it comes to any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoffs, training, benefits, and any other terms of employment. Additionally, it is unlawful to subject an employee to workplace harassment. Harassment generally occurs when a supervisor, coworker, or even a non-employee in the workplace subjects an employee to hostile, offensive, or intimidating behavior because of gender identity or gender expression. To be illegal, the harassment must be severe or pervasive. In California, harassment is actionable when it disrupts the emotional tranquility of the person being harassed. Examples of harassment specifically against transgender workers can include intentionally and repeatedly using the name that a transgender person was given at birth and no longer uses upon transitioning, also called a dead name, and continually using incorrect pronouns to refer to a transgender employee. Harassment can also look like offensive or derogatory remarks about a person's transgender status or gender transition. It is also illegal for an employer to retaliate against, harass, or otherwise punish any employee for opposing employment discrimination that the employee reasonably believed was unlawful, filing an EEOC charge or complaint, or participating in any investigation, hearing, or other proceeding connected to Title VII enforcement. Moving next to California law, California's Fair Employment and Housing Act, also known as FEHA, makes it illegal for any employer with 5 or more employees to fire, fail to hire, or discriminate in any manner against employees who are or are perceived to be transgender or gender nonconforming, or one employee if there is a claim of sexual harassment. FEHA also prohibits harassment on the basis of gender identity or gender expression, regardless of the employer's size. Next, I'm going to provide some actions you may want to consider taking if you believe you are being discriminated against or harassed at work because you are transgender. Being discriminated against at work is really difficult and often painful. I know that some of these steps may seem like a lot of extra work to do on top of the stress you're already feeling right now. We include them because these steps will help build the evidence necessary to advance an investigation or lawsuit showing that you have been discriminated against based on your gender identity. Also, these agencies receive a lot of complaints. The more evidence you have, the more likely they are to devote attention to your case among the many that they review. Here are some steps that you may want to consider taking if you feel you are being discriminated against at work. 1. You could document what is happening or has happened to the best of your ability. For example, you could take notes and date them or timestamp them. Take them electronically if you are able to so that the notes can be dated using the metadata. For example, we've seen folks email themselves notes of the discrimination that they experienced that day so that there's a timestamp of when it happened. However, any way that you record your notes will work. A handwritten journal with detailed notes of the incident and timing will work too. Save or screenshot emails, texts, and other relevant messages. But when you do this, please be aware that recording someone without their permission may be unlawful. You should also save any other papers that may be relevant. And you should make sure to document this on personal devices or at home, and not on work devices. While retaliation for reporting discrimination is illegal, it may be safer to keep your evidence collection private and separate from work. Another step to take is to try and develop a timeline of events. Include the date, time, and who was involved in each relevant event, instance of discrimination or harassment or conversation, especially if a supervisor was involved. If in doubt, avoid signing anything related to the discrimination, harassment, or retaliation without talking to an attorney, especially documents that require you to agree to waive your right to bring a lawsuit or require you to arbitrate disputes with your employer. You could try and talk to your HR department if you feel comfortable or you think that they will be supportive. If you are represented by a union, you could also try contacting your union representative. You may also want to contact a legal aid service, such as Legal Aid at Work, who partnered with us on this video. Their contact information is included in the description below. Or you may want to file a complaint or charge with a federal or state agency, which is what I'm going to talk about for the remainder of this video. Filing with an agency can be a complicated process. Each agency will have its own method for filing complaints, as well as its own deadlines. Filing with an agency is important because you must file a complaint before you are able to file a lawsuit for employment discrimination. I am going to give an overview of the federal and the California agencies where you could file a complaint, called the EEOC and the DFEH, respectively. In many cases, a complaint can be filed with either agency at the time you file with the first agency. The form may ask you if you would like to file with both the EEOC and FEPA, which stands for Fair Employment Practices Agencies, and refers to the Fair Employment Agency in your state. The agencies will then share information. This information sharing is sometimes called cross-filing. However, I'm going to outline the process for both agencies because you can only file with the federal agency if your employer has at least 15 employees, but you can file with the California agency if your employee has at least 5 employees, or 1 employee for harassment claims in California. The federal agency where you would file a complaint is called the Equal Employment Opportunity Commission. It is commonly referred to as the EEOC. The EEOC only accepts complaints if an employer has 15 or more employees. Employees of private businesses, state or local governments, also called non-federal employees, usually have 300 days from when the discrimination took place to file a complaint. This 300 days applies in California because we also have a state agency. If your state does not have a state agency, a shorter 100-day time frame will apply. Most employees will fall under this non-federal employee category. However, employees of the federal government have only 45 days to file a complaint. All federal employees will have an EEO officer at the agency where they work or where they applied for their job. Contacting this EEO officer is the first step, and that officer will go through your options with you. For almost all other employees, the first step is to file a charge of discrimination. A charge of discrimination is a signed statement asserting that an organization has engaged in employment discrimination, harassment, and/or retaliation against you. It requests the EEOC to take remedial action. The charge can be submitted online or in person at an EEOC field office. It cannot be submitted over the phone, but you can call the EEOC with any questions about submitting the charge of discrimination. The EEOC will then contact your employer and conduct an investigation. There are several possible outcomes after filing a charge. If the EEOC is unable to conclude that there is reasonable cause to believe that discrimination occurred, the charging party will be issued a notice called a dismissal and notice of rights. This notice informs the charging party that they have the right to file a lawsuit in federal court within 90 days from the date of its receipt. The employer will also receive a copy of this notice. In our experience, EEOC investigators apply a high standard of review, so we generally encourage people to keep fighting even after the EEOC determines that there is not enough evidence to proceed. If the EEOC determines there is reasonable cause to believe discrimination has occurred, both parties will be issued a letter of determination stating that there is reason to believe that discrimination occurred, and inviting the parties to join the agency in seeking to resolve the charge through an informal process known as conciliation. Conciliation is a process where the EEOC facilitates a conversation between the parties in an attempt to resolve the issue without going to court. When conciliation does not succeed in resolving the charge, the EEOC has the authority to enforce violations of its statutes by filing a lawsuit in federal court. If the EEOC decides not to litigate, you will receive a notice of right to sue and may file a lawsuit in federal court within 90 days. The California agency is called the Department of Fair Employment and Housing, or the DFEH. The DFEH will accept a claim as long as an employer has 5 or more employees, or 1 employee for harassment claims. So if you work for a smaller company, this may be the only agency that you can file with. Similar to the EEOC, the first step with the DFEH is to file an intake form. You can do so online, by mail, or by telephone. To file, the DFEH requests that you have the following information. 1. The specific facts and any records about the incident, including the name and contact information of the person or entity you believed harm you, if known. 2. Copies of any documents or other evidence related to your complaint. And 3. The names and contact information of any witnesses, if known. In employment cases, you need to file with the DFEH within 3 years of the discriminatory incident. If the incident of discrimination occurred more than 300 days ago, but within 3 years, you can still file with the DFEH, even though you cannot file with the EEOC. In employment cases, if you would like to sue your employer, you must obtain from the DFEH a right to sue notice before filing your own lawsuit in court. If you would prefer not to use the DFEH investigation process and instead file your own lawsuit, you can obtain an immediate right to sue notice. The DFEH will evaluate the allegations in the intake form and decide whether the laws that the DFEH enforces cover those allegations. If these laws cover your allegations, the DFEH will prepare a complaint form for your signature. When you return the signed complaint, it will be delivered to the person or entity that you believe discriminated against you, usually your employer. The department will then investigate the facts and legal issues in your case. The DFEH generally would like parties to resolve complaints through its mediation services, which attempt to resolve disputes without going to court. The DFEH could also file a lawsuit against the employer that discriminated against you. Before the DFEH files a lawsuit, it typically requires the parties to go to mandatory mediation. If the DFEH believes that the laws do not cover your allegations or the case is closed, the DFEH will give you a right to sue letter. Also, it is important to know that it is illegal for your employer to retaliate against you for going to either of these agencies. Retaliation is anything that would be likely to discourage employees from protesting and reporting discrimination. Retaliation may include actions such as terminating you, moving you to less favorable shifts, giving undeserved negative reviews, or intensifying the original harassment. Before we conclude, I also want to acknowledge that filing a legal complaint can be difficult, time-consuming, and stressful. Filing a complaint or a lawsuit is a very personal decision, and the legal system may not always be the best place to vindicate your rights. You can and should make the best decision for yourself when it comes to filing a complaint. This concludes our video explaining your rights and options for if you are discriminated against at work. In the caption of the video, I've also included some legal aid organizations you can reach out to. Thank you for taking the time to watch this video.